Due Process, winner of 18 regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights and the 2010 Mid-Atlantic Emmy for Best Discussion Series.
Why in this country, which is a democracy, why should these people, 9 unelected people, have the power to tell us what to do, or what, put it more specifically, why do they have the power to set aside a law that was enacted by our elected representatives in Congress or in the state legislature?
He is one of the 9 on this country's highest court. Justice Stephen Breyer, part 2 of our Due Process special, up next.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.
Making Our Democracy Work. That's the title of Supreme Court Justice Stephen Breyer's book on the relationship between the nation's high court, its government, its citizens, and the document on which it all rests.
So we were only a little surprised when Justice Breyer reached into his pocket in the middle of our taping on location at Rutgers Law School and pulled out a miniature copy of the Constitution. I'm Sandra King.
And I'm Raymond Brown, and it's with that moment before a captivated law school audience of nearly 300 that we pick up our Due Process special, our conversation with the ever-engaging Justice Breyer.
I say there is no secret. This is a great document, brilliantly written. It's designed to last the ages. But that isn't the whole secret. The whole secret is 200 years of history, which has had many ups and downs. And there are many stories in that time that show how gradually Americans have gradually, sort of, up to a point, accepted the idea that they will follow what judges suggest, say, hold is the law, even though they think it's wrong, and it might be.
But as you point out in the book, if we go back to the middle of the last century and we look at Brown, we saw people not willing to conform to what the court said. What was the lesson of that? And did Brown, too, which pulls back in order to try to garner support, was it worth it to say with all deliberate speed rather than right now?
Well, I'm not going to get directly to the answer because I want you to see that Brown took place against a background. In the 1830s, a lot of people know this case, but they don't know they know it. There were a group of Cherokee Indians who owned northern Georgia. It's theirs. The Georgians work out that the Indians have gold. So the Georgians think, why should the Indians have it? Why shouldn't we have it?
Right.
And they grab it. Very simple. Well, this Indian tribe of Cherokees is a pretty civilized group. They had an alphabet, they had a constitution, they'd given up hunting and fishing, they were farmers like their neighbors, and they did the only thing a civilized person would do: hire a lawyer. So they hired a lawyer. Greatest lawyer of his day, Willard Wirt, he went to the Supreme Court, and to make a long story short, of course, he won. The Supreme Court said this land belongs to the Indian tribe, it does not belong to the Georgians, and the reason you know that case, or have a vague recollection, is that is the case of which the President of the United States, Andrew Jackson, supposedly said, John Marshall made his decision, now let him enforce it. And Jackson sent troops to northern Georgia, but not to enforce the decision, rather to evict the Indians. And the Indians were evicted, and they traveled along the Trail of Tears, called that because so many died along the way. And their descendants who survive to this day live in the land of Oklahoma. All right? Now, a lot of time passed, and there was a civil war, and there was 80 years of legal segregation in the United States. And then came Brown. Now, do you know what happened the first year after Brown was decided? Nothing. Nothing happened. No, let me not exaggerate.
Well, Emmett Till was lynched.
Ah, yeah, thank you. That's right, Emmett Till was lynched. And not much happened. You know what happened a year after Brown 2 was decided? About the same. About the same. Now, in 1957, about 3 years later, a federal judge in Little Rock said, time to integrate. And a group of children who are now known as the Little Rock Nine, who were very brave, I'll tell you, and they agreed, black children, to be integrated into that white high school, Central High, where I was. I've seen it. It works. It's an integrated school. It's a great school. But that time, 100% white, no integration. And the federal judge said in September 1957, these 9 children will go into that school. Fine. What happened? Well, some of us remember. Governor Faubus got up and said, well, the White Citizens Council sent a few people here. There were many thousands, or hundreds anyway. Those children will not go into this white school. They won't. What happened next? Well, it was chaos. And pictures were taken. There was a famous photograph of a black girl, Elizabeth Eckford, trying to walk towards the school, and a white woman in back of her face just contorted with rage. And that picture went around the world. And it said to the world, this is the United States of America. So Eisenhower had to work out what to do. And I'll tell you one thing, it wasn't necessarily going to be an easy choice for him. But Herbert Brownell, his attorney general and wise counselor, said to him, you have to. You have to do this. It is a question of the rule of law itself. Not just integration, but both. And Eisenhower decided pretty quickly, I'll send the troops. And the next day, they brought those 9 children to that high school. And pictures were again taken of those children, black children, going into that white school proudly, with dignity, surrounded by the troops. But that showed something was happening in the United States of America. And for me, that picture, that day, is a great day. It's a great day for the rule of law. It was a great day for the cause of equality. It was a great day for this country. The miracle of the courts is that we've developed a way so that people who think very different things about very important things can reach decisions without killing each other.
On the court, Justice Breyer, we know that there are people who arrive at where they come to on a given case from different places, using different methodology. You talk in the book a lot about a value-driven, pragmatic approach to law. What do you mean by that, and does it, by definition, place you at odds with the other side, the originalists, the textualists?
Yes, the answer to both questions is yes. Where does that put me in light of my colleagues? And now we're on to a more technical but very interesting subject to me. Remember, 40% of the time we're unanimous. You might not know that from reading the newspapers, but 30 to 40% of the time we are unanimous. And the 5-4 decisions are probably 20 to 25% of the cases. And it isn't always the same 5-4 kind of lineup either. But still, there are a lot of important cases that go that way. So if I say, what is it that determines that? I'm just afraid if I got the answer, about 80% of you, probably 90% of most Americans would say it's politics. That the Supreme Court, really a group of junior league politicians. I said, that's not right. You say, that's what I have to say. But it's not right. Indeed, it's not. I wanted people to read Dred Scott because I wanted them to see what happens when you decide a case via politics, because I thought that's the only explanation I have, that Chief Justice Taney thought somehow he was going to end the possibility of a civil war, and if that was so, he caused a civil war, or he helped cause it. And so judges are terrible politicians. So one, they're not fitted for it, And two, it isn't their job anyway.
Can I interrupt you and ask a question about Charles Hamilton Houston, who was Thurgood Marshall's mentor and really the strategist behind Brown?
That's true.
He once said that a lawyer who's not a social engineer is a parasite, which is obviously said in the context of the civil rights movement. But I have two questions, since you talk to young people, A, what you think about that, and secondly, to try to prejudice the outcome. Is not your writing a book about the legitimacy of the institution you serve a form of social engineering?
Yes.
Okay.
It's a form of social engineering through
So does that help me
explanation.
with the answer to the first question? What you think about his statement?
Yes, it does, because I tend to think of that as a reference to the fact that law itself does consist of a system that's designed to help people live better together. As you see, the law can either fit together better or fit together worse to accomplish a human objective. And no judge has freedom to just rewrite that law. In the First Amendment, it's a matter of expression. In the Fourth Amendment, it's a matter of search and seizure. But all of these are written to affect human beings. They are not simply a matter of computer logic. And so what probably Charles Hamilton Houston was most concerned about is we had a law. That law was called the 14th Amendment. That amendment says that no state shall deny any person of equal protection of the law. It was passed for a reason. The reason it was passed was there were people who had been slaves, and they and their descendants were to be brought in a condition of equality into American society. And for 70 years, with a system of segregation, that had not happened. And so the problem was, how can we get the courts, looking at it with retrospect, to apply this law as it was written and as I believe was intended?
Justice Breyer, we're here in Newark in the home of Justice Brennan. So we can't forget him and his getting to 5.
Yes.
A kind of political maneuvering to get that 5th vote, which he always said was paramount importance. Do you see yourself as being one of those people who tries to get to 5, and have you been successful?
Well, he was very successful at that. I wouldn't necessarily know I'm particularly successful or not. What you need from a court is a decision about the meaning of the Constitution, and to do that, you have to get to 5. And everyone knows that. And so everyone tries to get to 5. Now, try means don't insist on everything your own way.
I wonder, Justice Breyer, whether Supreme Court justices are like the rest of us in second-guessing ourselves. Is there a case, a decision, whether it was a majority decision or a dissent, that you now look back on and say, I wish I hadn't done that?
Yep.
And I guess we're not going to hear...
Well, how many?
Not too many. Not too many.
Another question. Professor Trachtenberg.
Justice Breyer, I'm struck by 2 recent 5-4 decisions of the court this month, one in the Arizona Christian school case, narrowing the standing of taxpayers, the other in AT&T Mobility, in which you wrote the dissent, which rejected a California law dealing with arbitration. And I'm wondering, despite the obvious differences between those 2 cases, whether you see any common ideological or doctrinal thread between them.
Well, I certainly would like to give you a better answer, but I call it tomorrow is another day. We decided this case. You and I were allies. You were both on the court. We were allies. That doesn't mean we'll be allies in the next case. The next case comes along from a legal point of view. It's a new world. And that means just even on the kind of question you're asking, I'm going to treat the next case afresh. That's why you, as an observer, are in a better position to answer that kind of question than I.
Before we get to other folks who want to ask questions, I wanted to first point out that you do deal with the Guantanamo cases in the context of the book. And it's part of the same larger argument. One of the things that you do is give what seems to me to be a pretty good exposition for non-experts as to what those cases were about.
That's right.
You do seem to, though, in dealing with those cases, deliberately not get much into the contextual, the other issues surrounding it.
Yes, because I want to illustrate a kind of situation that comes up occasionally and is terribly important, where a judge is forced to balance in a practical way certain values, and where that comes up with a vengeance. And by vengeance, I mean tough and difficult, is where values of ordinary human rights protection conflict with national security needs in a time of war or a time of national security crisis. And I want to contrast that with a case that is well known to some of you, Korematsu, where in World War II, 70,000 Americans of Japanese descent citizens were taken against their will from their homes on the west coast of the United States and moved to camps. And in 1944, the Supreme Court held that that was constitutional. How is that possible? They agreed to affirm this thing, and the question is how, and my answer to that is, in a sentence, they thought someone has to run this war.
In deference then to the executive.
Correct. It has to be Roosevelt or it has to be us, and we can't, so it's Roosevelt, and therefore what he says goes. And Guantanamo presents the same kind of issue, and I want to show how the court is struggling towards a different kind of answer.
Is there a student who wanted to ask a question?
Well, I'm noticing that you aren't liking speculative questions, but I'm going to ask you one anyway. And it's two parts. First, you know all of the justices personally. Do you think that we have any unexpected retirements coming up?
Well, if you did, no. I mean, they'd have to be unexpected, and I don't expect there to be anything unexpected.
Well, unexpected for us.
Yeah, I know. He said, do I have some inside information? Yeah. No. Everyone seems to be in good health.
And if there were, I was wondering what were the aspects of your resume that were relevant when Clinton nominated you?
That you'd have to ask him.
He didn't ask you any questions?
Oh, I know. I had lunch with him the year before. But what is in the president's mind when the president appoints a person is best known to the president.
In your book, you really make a good case for transparency, for helping the public to understand what it is you do. Wouldn't the best way to do that be to have cameras in your court and perhaps in all the federal courts?
No, there are things pro and con on that. There are things pro and con.
Where do you come down?
I haven't had to. I haven't had to because there is opposition in our court to the point where I've been able to retreat myself into saying I have enough to decide. I don't have to vote on this one. But I'd like you to see some of the things con as well as the things pro. The pros are, from what I'm doing in this book, fairly obvious. The pros are that if people could see the courts in session some of the time, if they saw our court, they would see 9 people who really are trying to do their job. And they'd get a bit more of an idea of what that job is. And of course, my whole object here, and the reason I'm here, and the reason I'm embarked on this kind of enterprise is because I think it's important to tell younger people particularly. Say there are 800 in some odd students at the Rutgers Law School here. They should know or a little bit about our history and understand what their institutions are, courts, legislatures, and so forth. They should understand that, and they should participate. All right, that's the hidden message, and it's not so hidden.
But on the opposite side.
Right, the opposite side. One worry is that it's the Supreme Court of the United States. If television were in our proceedings, it would be in every criminal proceeding in the country, and there are genuine problems where you're talking about witnesses in criminal cases and jurors. That's one. 2, the oral proceeding is 3%. We're really a court that decides things according to writing. And people wouldn't understand that. Now, I mention those knowing that I don't know how important they are compared with the first.
Well, you haven't
and I know we're living in an era.
No,
I haven't.
But clearly you've thought a lot about it.
Yeah, I've thought about it. And I've said sometimes, there are research institutes, there are academics, there's a lot of experience. People could look into this, and they could have studies that weren't paid for by anything to do with the media. And there are ways of learning more or less, but that's my academic side coming out. And as soon as I say anything like that publicly, people go on to some other subject.
Let's go to the audience for another subject. Questions?
Welcome to Newark, Justice. My name's Rosemary Gambardella. I sit on the bankruptcy court here. I have one question. I know you've spoken at length about the reference to foreign law, foreign treatises in making decisions. And as I understand it, that's a matter of some controversy. How have your views evolved Have they changed? And what is the merit in looking to those laws? Not as far as stare decisis, but in informing our reasoning and our ultimate decision-making as judges.
Yes, that's a good question. And you say, what am I thinking about that? I tend to think of it as follows. I tend to think of it as there's a really exciting, dramatic question there, which is not of great practical importance. And there is a question that is very boring, and it is of enormous practical importance. The question that is very exciting and not of much practical importance is, should we look to courts in other constitutional courts in other countries when we decide important constitutional cases? There, my answer has been yes. If they're relevant, we can read them. We're not bound by them, but why not read them? We might learn something. My point is that they're judges, persons who have jobs something like mine. More and more countries are democracies. More and more countries protect basic human rights. And so if a person who has a job like mine, who has a document something like mine, who has experience something like mine, who's facing a problem something like mine, writes opinion on a subject, why not read it? It doesn't bind me. Maybe I'll learn something. Okay? Now, other people have different points of view.
But why
there.
do you think you took so much criticism when you've done that?
Well,
including
why so much
from fellows on the
criticism?
bench?
Why so much criticism? Because I'll tell you, I had this discussion with a congressman once who were at some kind of meeting with some academics and members of Congress and judges, and I made that point. Didn't you think that was a good point? I thought it was great. So I made that point. Now, here's what he said.
Doesn't everybody get to vote?
Yeah, no. He said, first he started out with a big criticism of this. So then he said, why are you always referring? I said, not always, very occasionally, but why not? I made the same point. You know what he said? He said, fine, read it. He said, just don't refer to it in your opinion. And the reason is, I think it's politically, people are nervous about referring to a non-American source. So that's why.
Justice Breyer, let me come back to, because I think it's important. For example, in the death penalty context, where it's really the international law references are really so far down the ranks of hierarchy that they're really not essential to understanding the opinions. And yet the response there and to Justice Kennedy in the case involving sodomy have just been tremendous and political. And so the question is there something in our view of law in the context of your thinking about how courts deal with problems that makes us frightened about something that comes from afar, no matter how much you might say it's a democracy just like ours, and I'm just using it in this minute way? Why is our reaction so disproportionate to the impact in the decisions
what you say is possible. My wife is a psychologist, a clinical psychologist, so she's explained to me there's something called displacement. And displacement means you're angry at A, so you blame B. Now, the cases, you are quite right, that these constitutional cases have involved homosexual conduct, homosexual sodomy, and also the death penalty. Those are not free of political controversy. And so possibly X, who is angry at the results in that case and doesn't like them, decides not to blame the case, blame B. And poor international law, references there too, are getting the displaced wrath. I mean, I don't know all the law in the world. It's amazing I know any. And the point is, we are told about these laws by the lawyers. And we're willing to look at it. Indeed, we must look at it.
Here we've got a law school audience. What's the single most important thing that any of these students should be taking away from an education at a law school?
I think you'll come away and being pleased with being a lawyer, and you will be lawyers, and that at the heart of this profession is something that calls for a good mind and a good education, and also a heart, by which I mean you understand the relationship of people to the law. Now, you come away from the law school with that, with a sense of how the law reacts, the way in which things can change or stay the same, and that's very complicated. But bringing it back to the emotional center, which is the heart of its purpose, which is how human beings live together in society. All that sounds fine generally, but you've taken 3 years to begin to understand that, and you take that idea away, encapsulate it in the courses that you've learned. I think that's just fine.
Justice Breyer, thank you so much. This has been a wonderful session, and we're very grateful. Thank you.
Thank you. What you need from a court is a decision about the meaning of the Constitution, and to do that, you have to get to 5. And everyone knows that. And so everyone tries to get to 5. And the problem is that sometimes you just can't say it. So the question is, what is the line? If you're too pernickety about having everything your way, you won't get court decisions, and that's not the job. I mean, that's a great job when I was a professor. I mean, I can write down as a professor everything I think is absolutely right. It's a terrible way of describing my job as a judge. My job as a judge is to help a court get to a decision. So I will, in fact, and others will, in fact, try. Now, try means don't insist on everything your own way.
Thank you so much for coming.
Major funding for due process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.